So today's session is based on rights of creditors and debtors. Now, before we jump into what are the rights and of the creditors and debtors, first we must understand who are the creditors and debtors. So, in layperson's language, a creditor is someone to whom money is owed, and a debtor would be someone who owes money and who's under an obligation to pay that money. So this is the basic definition of a creditor and debtor. Now, of course, under various statutes, there are a number of definitions for not only creditors, secured creditors, financial creditors, operational creditors, as the case may be. Now, in this webinar, I'll try to touch upon some of the basic concepts and some basic rights of creditors and debtors, starting with SARFAESI Act, which the full form is Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. In short, we just call it SARFAESI Act. So SARFAESI Act, basically the object behind bringing SARFAESI Act was because the banks and financial institutions, so the object behind SARFAESI Act was that so that banks and financial institutions can recover their money without much intervention of courts and tribunals. So SARFAESI gives a right for the creditor, be it a bank or a financial institution, to take back the property which is given as security without much intervention of court and tribunal, and just auction it off and sell it. So all of these, before all of this comes, how does a creditor, as like a bank or a financial institution under SARFAESI, go ahead? So the first thing that happens is when a creditor, like a bank or a financial institution, gives loan to a debtor who will mortgage some property, create some charge on his property, and ask for some loan. And if those installments which he monthly pays to the bank as EMI, if he defaults in payment of those EMIs consecutively and his account turns NPA, that is a non-performing asset, then the bank or the financial institution has to send a legal notice to them under section 13(2), informing the creditor, informing the debtor about the liabilities that has accumulated, informing him that, look here, your account has been turned NPA. Now, if you don't regularize your account, we will go ahead with SARFAESI proceedings, sell off your asset and recover our dues. So of course, a bank or a financial institution basically is a secured asset. Now, what is a secured asset and an unsecured asset, you may ask? A secured creditor, like a bank, has secured assets. It your When you go to a bank and get a loan, you have to give papers of your property, or you have to pledge some property to the bank, which will be as a collateral they'll keep, and they'll give the loan to you. So if a bank or a financial institution has some security, which in the event of the debtor defaulting, they can go ahead against the security and they can take back their money, then that's a secured creditor. Now, what would be an unsecured creditor? An unsecured creditor in that sense would be someone giving loan to their friend, as a normal enough friendly loan or something like that, where you don't have a security as such. When a friend asks you for money and you just lend him money, he may give you a promissory note, he may give you a blank check signed by him saying that you can encash this after 90 days or whatever the case may be. But an individual person does not have right to either take a security or call himself a secured creditor. Either a bank, a financial institution may do that. So when a person who gives a friendly loan has no security, he is an unsecured creditor, and he has no security. If my friends fails to repay me back, then I have no security. I have to, either if there's a check, then I have to go ahead and file a 138 if the check is dishonored, or I have to file a summary suit against my friend. Now, since we are talking about SARFAESI, this deals with banks and financial institutions who are secured creditors. So the bank will give a notice under section 13(2) of the SARFAESI Act, informing the debtor about the liability that has been occurred, and then it will call upon the debtor to repay that money. And basically this is the right of the creditor to claim that outstanding money. And what is the right of the corresponding right of the debtor? So the debtor has a right that under 13 subclause 3, first of all, under 13 subclause 3 of SARFAESI Act, he has a right to know how much liability he is bound to pay back to the creditor. And under 13.3, if he disputes the amount, or there's some deficiency, some issue, some objection the debtor has, then he can write to the creditor and say, I object to your SARFAESI notice because of so and so reasons. And this is the right of debtor and corresponding right of debtor. And this 13.3a of SARFAESI is a mandatory provision. So if the bank does not give me an opportunity, or if I raise an objection under 13.3a of SARFAESI and they don't reply to that objection, and they just go ahead with the SARFAESI proceedings, then I as a debtor have a right, corresponding right, financial institution before DRT under section 17 of the DRT RDB Act. So that is the right of a debtor. If I say that there is some right under the statute which the bank or financial institution has failed to adhere to, then I can challenge the SARFAESI proceedings. And if they have taken the possession, that possession can be restored back to me, and they will have to again initiate the SARFAESI proceedings against me if there is still a default. Now, under section 13 subclause 4, also the borrower, there is also a right of creditor, and in case that borrower fails to discharge his liability, the creditor may take recourse and he may take the possession of the secured asset without intervention of the court. Of course, the creditors have either the right to take back the possession themselves if there is no issue, if the debtor does not create any encumbrance, or he's not stopping the creditors from taking, they can clearly take the possession back without the intervention of court or tribunal, as that is the object of SARFAESI Act. But let's say in a case that the debtor is not ready to give back the possession to the creditor, then the creditor has a right to apply under section 14 of SARFAESI to the magistrate, saying that this under this securitization application, that this is the case, he has defaulted, his account is NPA, now he's not giving me the possession. And if he refuses to give possession, then the magistrate, if he's satisfied, he can direct the police that you take possession and give it to him. So this is the right of a creditor to get the possession of that secured asset. Now, of course, under 13.8 subclause 8 of the SARFAESI Act, there is also a right of debtor, and he has the right of redemption, where the amount of dues together with all costs and expenses is tendered to the secured creditor before any time before date of publication of notice for public auction or inviting quotation of tender from public or private treaty, the assignment or sale or of the secured asset. The secured asset shall not be transferred by way of lease agreement. So basically, under 13 subclause 8, the debtor always has a right to tender all that is outstanding and say that you give me my property back. As you all know, that right to property is not a fundamental right anymore, but yet it is a constitutional right under Article 300A of the Constitution of India. So if a debtor goes and says that I'm ready to pay whatever default is, that you hand me over my back my property, then he's entitled to that under 13 subclause 8 of the SARFAESI Act. And under 13 subclause 10 of the SARFAESI Act, the creditor, if let's say the loan is of 1 crore, if from the secured asset I am only able to recover 75 lakhs and 25 lakhs plus interest is still outstanding and the debtor is not paying me, then as a secured creditor, as a creditor, I have a right to apply to DRT and ask for that additional outstanding whatever amount may be. And of course 13.8 protection is there for the debtor to say hand over all the money outstanding and get back the property. So the Honorable Supreme Court, while dealing with 13.8 of the SARFAESI Act and the protection granted to a debtor in the matter of Matthew Verghese versus M. Amrita Kumar, 2014 5 SCC 610, has said this. Section 13.8 protects the ownership right of a borrower slash debtor, that is right of redemption, which is a constitutional right under Article 300A of the Constitution. Section 13.8 gives opportunity to borrower, the owner of secured asset, to take all efforts to stop sale, transfer of secured asset till last minute by tender of dues inclusive of costs, charges, etc. to the secured creditor before the date fixed for sale of transfer of secured asset. Once such tender as stipulated in section 13 subclause 8 is made by the borrower, it is mandatory for the secured creditor not to effect sale or transfer of secured asset and also not to take any further steps for the same. So basically, a bank's or financial institution's end goal is to get back their money. If a borrower comes ahead and says that I am ready to give back all that is due along with charges, costs, whatever you may have incurred, the creditor is under an obligation to return back the property, and the debtor has a right for redemption of his personal property, which is a constitutional right. Of course, the debtor has also the right to challenge the SARFAESI proceedings under Section 17 of the RDB Act before the DRT. And if the bank or financial institution has failed to follow the procedure prescribed, if there is some latches on their behalf, the debtor can approach DRT and always say that the action taken is not in consonance with the what the act and the rules thereunder stipulate. So this action of the bank or the financial institution may be set aside, and that happens in some of the matters. Now I'll just read some important judgments which I have personally come across under SARFAESI Act. One is ITC Limited versus Blue Coast Hotels Limited. This is a 2018 Supreme Court judgment. In this, while dealing with 13 subclause 3A, which I was mentioning, that the debtor has that right to object, the Supreme Court says that Section 13(3)(a) of SARFAESI requires creditor to reply to the objection of debtor. Though the requirement is mandatory, we are of the view that 3A of Section 13 cannot be of any avail to the debtor whose conduct has been merely to seek time and not repay the loan as promised. So under 13(3)(a), there is a right for debtor to question it. But in this case, what has happened was the conduct of the debtor throughout has been only to delay the process. He did not intend to actually redeem the property and get back his property. So Supreme Court said although there is the protection under 13(3)(a) to a debtor, but looking at the conduct of this creditor, this debtor, we are not inclined to grant him protection under 13(3). So this is a very important judgment because although there is a right under the statute, the courts may sometimes look at the conduct of a party and decide to not grant them injunction or support them. The next case is Dwarika Prasad versus State of UP. This is also a Supreme Court judgment. This deals with 13 subclause 8 of the SARFAESI Act, and the Supreme Court says that 13 subclause 8 of the SARFAESI gives right to borrower to redeem the property by tendering all the dues to the secured creditor at any time before the date fixed for sale of transfer. The right to redemption stands extinguished on the execution of registered sale deed. So if the debtor fails to repay, let's say auction takes place, someone is successful in the auction, he purchases, and a registered sale deed is executed in his favor, then this right of redemption goes away, and then the debtor does not have a right. The next one is relating to the right of the creditor, which they have a right to either take the possession under 13(4) of SARFAESI by themselves or take the help of a magistrate under Section 14 of the SARFAESI Act. It's a Standard Chartered Bank versus Noble Kumar 2013 9 SCC 620. Secured creditor can take possession under Section 13(4) of SARFAESI or under Section 14 with the help of magistrate. So this basically tells the creditor what rights they have, under what section they can take back the property. Next is J. Rajiv Subramaniam and another versus Mrs. Pandyas. The Supreme Court has reuttered basically what the constitutional right a debtor has under Article 300A. Secured asset is a constitutional right vested in the borrower and protected under Article 300A of the Constitution of India. Therefore, The secured creditors, as a trustee of the secured asset, cannot deal with it in any manner it likes, and such an asset can be disposed of only in the manner prescribed in the SARFAESI Act 2002. Therefore, the creditors should ensure that borrower was clearly put on notice of the date and time by which either sale or transfer will be effected, in order to provide the required opportunity to the borrower to take all possible steps for retrieving the property. Now, of course, apart from SARFAESI Act, the bank or a financial institution has also the right to move to DRT under RDB Act, which is Recovery of Debts and Bankruptcy Act 1993. And in that act, the bank or the financial institution may initiate an original by filing an original application before DRT, and the only condition is that the minimum default should be 20 lakhs. If the loan is less than 20, then DRT under this RDB Act cannot be approached. Then the creditor has to go and file a regular suit, as the case may be. Now, apart from, of course, SARFAESI and DRT, the banks also enter into hire purchase agreement. As in, if you go and you want to buy something on EMI, so hire purchase agreement is basically that the bank or financial institution from whom you take this on loan, the on EMI, is the institution, is the owner of the asset. If, let's say, I want to buy a TV on EMI, I'll go and take some assistance of some bank or financial institution, they'll buy it for me, but I am not the owner. I am only taking that product on hire, and the bank or the financial institution is the owner of that hire till I've paid the last EMI. Only after I pay the last of my EMI, I am the owner of that. So this is also a type of right between a creditor and a debtor. In this case, the bank who's giving me the financial assistant to purchase this whatever electronic device, it may be a car or anything, is the owner till I pay the last of my EMIs, and I am a debtor. So a hire purchase agreement basically allows a buyer to purchase goods they don't own, the goods, until the last installment has been paid. You hire an item, for example, a car, laptop, or television, and pay an agreed amount in monthly payments, that is in EMIs. And if you fail to pay as such, they can take back that asset, because eventually they are the owners. They are a bailer, and as a bailee, we are just holding it onto them until we make the last of our installments. And once we do that, only then that product or item becomes ours, and then they cannot take it back. Now, of course, courts in India have always, deprecated the practice of taking forcible possession of any, maybe it may be a movable property or an immovable property, and courts have always insisted that parties are must go ahead with the due process of law to recover their assets. But it has also happened that in some of the cases, in a hire purchase agreement where someone has taken a bike or a car, and if they default in paying, the bailer or the creditor, as the case may be, has taken back that product, that may be a car or a bike, and people have filed criminal complaints against the bank or the financial institution, saying that they have stolen the property because I am the owner. So the court says, no, they are the bailer, you are the bailee. Until you pay the last of installment, they are the owner, and they are well within their rights if under the hire purchase agreement there is a clause that they can take back the possession of that item. So the Supreme Court in Lallu Yashwant Singh versus Rao Jagdish, AIR 1968, has said that taking forcible possession is illegal. In India, persons are not permitted to take forcible possession. The law respects possession. The landlord has no right to re-enter by showing force or intimidation. He must have to proceed under the law, and taking forcible possession is illegal. So even in cases where it's landlord, or whether it's the banks or financial institutions who are bailer, and actually in the sense legally they are the owners, they can although take, and if criminal action is initiated against that, the court will protect them. But court has deprecated the practice of taking forcible possession by show of muscle, and said that if a creditor you feels that the debtor is unable to pay, they must take the not take the law in their hands and follow the due process of law. The next judgment is K.A. Mathia alias Babu versus Kora Bibikutti, 1996 7 SCC 212. The court held that where the financer's hire purchase agreement contained a clause of resumption upon failure to make payment of installment, it could not be said that the financer had committed the offense of theft by taking possession of vehicle covered by the hire purchase agreement. So in this case, there was a hire purchase agreement. There was a specific clause that if the debtor or the in the hire purchase agreement debtor fails to pay installments, the bank as a bailor, as a legal owner, can take back the possession. And when they did take back the possession, he filed a criminal case of theft. Court said that no, theft is not maintainable because they in law they are the owner. Although they don't appreciate it and they deprecate the practice of taking it by forcible possession, but in this case, since in the hire purchase agreement there was a specific clause which allowed them for resumption, the court has said that there's nothing wrong in it and that it does not amount to theft. The next judgment of the Supreme Court is Anup Sarma versus Bholanath Sharma, 2013 1 SCC 400. In this, the court held that in an agreement of hire purchase, the purchaser remains merely a trustee slash bailee on behalf of the financer or slash financial institution, and ownership remains with the latter. Thus, in case the vehicle is seized by financer, no criminal action can be taken against the financer, as the financer is only repossessing the goods owned by the financer. The next judgment is ICICI Bank Limited versus Prakash Kaur, 2007 2 SCC 711. And this, the court has deprecated the practice. The court says the practice of hiring recovery agents who are musclemen is deprecated and needs to be discouraged. The bank should resort to procedure recognized by law and take possession of vehicle in cases where the borrower may have committed default in payment of installment instead of taking resort to strong arm techniques. So court has deprecated the practice of either the bank or financial institution or even landlords taking possession by force, and they have protected them against criminal action. But as far as civil liability goes, the court says there's no, you follow the due process of law. Of course, under other statutes like IBC, there are financial creditors, there are operational creditors. And under IBC, the financial creditor may be also a secured creditor or he may be an unsecured creditor. So under IBC, under section 7 of IBC, the financial creditor, if he feels that the debtor is unable to pay his loan or financial assistance that has been provided, they have the right to approach NCLT and get the corporate debtor or the debtor admitted to CIRP. They also have the right to move against the personal guarantors if the directors in their personal capacity have given their personal guarantees. They can also move ahead against the personal guarantors. So these are the rights of creditors under the IBC. Of course, there are also operational creditors who can initiate insolvency under section 9. The creditor under section 9 will have to give a demand notice under section 8, and then if there is no pre-existing dispute and operational creditor can show that his petition is within threshold, the court may admit it. So how an operational creditor works is, if I am supplying any product, or if you are using my leased out property for your operations of your company, then I'm an operational creditor, and I can if there is a debt which is more than the threshold, I can move ahead you before NCLT. Now, of course, under IBC, although it is not a recovery forum, and in some cases parties settle and the debtor is able to recover his dues, but IBC is not recovery forum. But of course, it also recognizes the right of creditor and the corresponding right of debtor for general principles of law like audi alteram partem. And if even if a financial creditor or an operational goes before NCLT, The natural justice principle is always followed. The debtor is given an opportunity to show cause why the company petition should not be admitted. So this is the corresponding right of the debtor under IBC. Now, this is as far as the secured creditors goes. What happens if I am an unsecured creditor? If I have given a loan to my friend who has given me post dated checks, what remedy will I have under law? So under law, of course, if my friend has given me check or he has given me promissory note, then of course I have, under, if there is a check under Negotiable Instruments Act, I can, if the check is dishonored, I can go ahead and file a criminal complaint under 138 of the Negotiable Instruments Act. If I have a promissory note, of course I can go ahead and file a summary suit against the debtor under Order 37 of the CPC. So these are my rights as a unsecured creditor. Now, before I go to the Negotiable Instrument Act, I'll just briefly touch upon Order 37 of CPC, which deals with the initiation of a summary procedure. So, under Order 37, Rule 1, Subclause 2, the court provides under which conditions or under which terms a summary suit can be filed. I'm reading Order 37, Rule 1, Subclause 2. Subject to provision of Subrule 1, the order applies to the following classes of suits, namely suits upon bills of exchange, handis, and promissory notes. Next, B says suits in which the plaintiff seeks only to recover a debt or liquidated damage or demand in money payable by the defendant with or without interest arising of a written contract on an enactment when sum ought to be recovered is a fixed sum of money or in the nature of a debt other than penalty or a guarantee where the claim against principal is in respect of debt or liquidated demand only, and suit for recovery of receivables instituted by an assignee of a receivable. So, of course, if there is a bill of exchange, if there is a promissory note, if there is a handi, you can go ahead and file it. But of course, this does not talk about anything about check. So, what happens if a check is there? The section only talks about either promissory note, bill of exchange, or handi. So, how can a creditor, an unsecured creditor who has only a check, come before summary procedure before a civil court? So, the answer to that lies under the Negotiable Instruments Act and Section 6 more particularly. Now, before I go into the negotiable instrument, I'll just complete this summary procedure thing. So, of course, what happens? What right does an unsecured creditor have? If, say, he has a promissory note or a check, he can go ahead and file a summary suit. He can say that these are the damages I'm claiming. The suit is of summary nature and I have not claimed any other rights. And if the court feels that yes, some case is made out, it will issue notice to the defendant. The defendant may appear. He may seek leave of the court. The court may consider if the defense of the debtor is a triable issue. If it's a triable issue, the court may consider granting him leave to defend. If not, then as a creditor, I'll have to give him summons for judgment. And if there is no defense or defense is sham or only a moonshine defense, the court will directly give me a judgment in my favor as a creditor, and then I can go ahead with the execution proceedings and recover that money. Now, of course, Order 37 Rule 2 deals with institution of summary suits, and it provides the manner in which the summary suit has to be initiated. And I'll just mention a Supreme Court judgment which deals with leave to defend. It's a recent Supreme Court judgment. BL Kashyap and Sons Limited versus JMS Steels and Power Corporation, 2022 3 SCC 294. So while dealing with leave to defend, the court said while dealing with an application seeking leave to defend, it held that it would not be a correct approach to proceed as if denying leave is the rule, or that leave to defend is to be granted only in exceptional cases or only in cases where defense would appear to be a meritorious one. On the issue of raising a tribal issue, if the defendant indicates that he has a fair or reasonable defense, he is ordinarily entitled to unconditional leave to defend unless there be any strong reason to deny leave. Further held, even if there remains a reasonable doubt about probability of defense, sterner or higher conditions could be imposed while granting leave to the defend, but denying leave would be ordinarily countenanced only in such cases where defendant fails to show any genuine triable issue and court finds the defense to be frivolous or vexatious. So generally in a summary suit, court is, if the court is satisfied that there is no defense or if the defense is sham, vexatious or frivolous, then the court will directly go ahead and give a judgment in favor of the creditor. But if the debtor is able to demonstrate even on the preponderance of probability or even a triable issue he is able to show, then the law is that he should be given the leave to defend that suit. That is the law. Then, of course, if one summon is issued under Rule 3 of Order 37, there's a procedure for appearance of defendant, and then when a summons for judgment is also delivered on him within 10 days, then he has to file his leave to defend. And if court feels that whatever he stated in his application is maybe not completely true or maybe not 100%, he has a very meritorious case, but if it's a triable issue also, then court will generally grant a leave to defend the suit. Now the Supreme Court has in a 1976 judgment basically referred to a decision of Calcutta High Court and has approved it. In a sense, the principles relating to the leave to defend, and which are very important, I feel, which basically boils down what the leave to defend boils down to, they have reiterated in that judgment. So I'll just read that because it is very important. What the Honorable Supreme Court says in the matter of McKellick Engineers and Manufacturers versus Basic Equipment Corporation 1976 4 SCC 687 is that if the defendant satisfies the court that he has a good defense to the claim on its merits, the plaintiff is not entitled to leave to sign judgment and defendant is entitled unconditional leave to defend. If the defendant raises a triable issue indicating he has a fair or a bona fide or reasonable defense, although not a positively good defense, the plaintiff is not entitled to sign judgment and defendant is entitled to unconditional leave to defend. If the defendant discloses such facts as may be deemed sufficient to entitle him to defend, that is to say, although the affidavit does not positively or immediately make it clear that he has a defense, yet shows such a state of facts as leads to interference that at the trial of the action he may be able to establish a defense to the plaintiff's claim. The plaintiff is not entitled to judgment and defendant is entitled to leave to defend. But in such a case, the court may in its discretion impose conditions as to the time or mode of trial, but not as to the payment into court or furnishing security. If the defendant has no defense or the defense setup is illusory or sham or practically moonshine, then ordinarily the plaintiff is entitled to leave to sign judgment and defendant is not entitled to leave to defend. If the defendant has no defense or defense is illusory or sham or practically moonshine, then although ordinarily the plaintiff is entitled to leave to judgment, the court may protect the plaintiff by only allowing the defense to proceed if the amount claimed is paid in the court or otherwise secured, or give leave to the defendant on such condition and thereby show mercy by enabling him to prove a defense. So ordinary rule is, if a triable issue is there, give leave to defend, and if there is no defense or if there is a triable issue but it's not very meritorious, but if court still feels that the defendant must be given a chance, it may say that, you know what, this is the amount, x amount claim, you deposit that x amount in the court and then we will allow you leave to defend this suit. So this is completes the summary procedure under Order 37 of CPC. Now I'll dealing with the Negotiable Instruments Act. Now under the Negotiable Instruments Act, Section 4 provides or deals with the promissory note. What it says is a promissory note is an instrument in writing, not being a banknote or currency note, containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to order of a certain person or to the bearer of the instrument. So if let's say I owe Malvika 10,000 rupees. If she is giving me 10,000, I'll give a promissory note. I'll say, I, Ashish Jha, say that I have taken loan of 10,000 and I promise to pay this 10,000 on so and so date. Now, if I fail to pay on so and so date, then Malvika has a right to go in the court, say that this is the promissory note which Ashish has given me. Now he has not repaid this amount. If the court, then the court will issue me summons. I have to enter my appearance as a defendant. If I am able to show that I have paid the money back to her, or that she has, retained this promissory note by making a false statement to me saying that she has lost this promissory note, and I've repaid this, or I have some triable issue which I can show to the court, then the court will grant me leave to defend the suit. Or else if I'm not able to show any defense, and if the court feels that the defense I'm taking is either moonshine defense, it's a sham defense, it's frivolous or a vexatious defense, then the court will say, no, 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 we are not satisfied with you. We will not grant you leave to defend this suit, and the court will directly give a judgment in favor of Malvika. So this is how promissory note works. Now, next is bill of exchange, which is explained under section 5. And it says that a bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or on order of certain person or to the bearer of instrument. So what is the difference between bill of exchange and promissory note is that in promissory note, the promise, whoever is promising his himself gives this note that I so and so say that I'll promise to pay you back and apply a revenue stamp to it and give the promissory note. In bill of exchange, the drawee who will get the money says that so Malvika has agreed that after I'll providing her with X, and after 90 days she will pay me for the amount which is of the X. Now this is the bill of exchange. I'll give this bill of exchange to Malvika. She will sign this bill of exchange and return it back to me. And if she then after 90 days fails to pay, then on basis of this bill of exchange, I can go and file a summary suit against her. Now section 6 of the NI Act I was mentioning deals with check. Now under order 37, there's no mention of check as such. And it just says that if it deals with a promissory note, a hundi, or a bill of exchange, then a summary suit is maintainable. Now, how a check for a check we can file a summary suit is explained under section 6, which deals with check. What it says is a check is a bill of exchange. So in this, it clearly says that it's a bill of exchange. So that is how it comes under Order 37, because a check is a bill of exchange. So and a bill of exchange, you can always file a summary suit. So this is how the check comes into summary court's jurisdiction. A check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and it includes the electronic image of a truncated check or a check in electronic form. Now, what if a post-dated check is given? The court in AR Dahiya versus SEBI 2016-14 SCC 370 says that post-dated check held is amounts to promise to pay, and that promise would be fulfilled on the date mentioned on the check. So if a post-dated check is given, then also it's a promise to pay. And based on it, I can either go ahead with 138 NI Act proceedings against the debtor, or I can also go ahead with a summary suit. Now, of course, there's also presumption under the Negotiable Instrument Act, and I'll just point out that for relating to presumption of negotiable instrument, there's section 118 in the Negotiable Instrument Act, which is very important, which you may read later on, which says presumption as to the negotiable instruments. Until the contrary is proved, the following presumptions shall be made. The presumptions are relating to consideration, B, as to the date. So whatever is date is mentioned in the check or instrument, it is the date. As to the time of acceptance, as to the time of transfer, as to the order of endorsement, as to the stamp, that the holder is holder in due course. So under the Negotiable Instrument Act, there is a presumption in favor of a creditor that whatever the negotiable instrument says, if it's a promissory note or a check, then it is presumed to be correct, and it is for the debtor to establish to the contrary. And unless he proves it to the contrary, I of course get the benefit of this presumption and as a creditor. Now, dealing with this section 118A, there's an important judgment of Supreme Court. It is Malla Varappu Kashi Vishweshwara Rao versus Thadikonda Ramula firm, 2008 7 SCC 655. It deals with section 118A, which deals with presumption of consideration. The court says that presumption of consideration, the initial burden is on the defendant to show the existence of consideration was improbable or doubtful or illegal. If this burden is discharged, the onus shifts to the plaintiff. If, however, defendant fails to discharge initial burden, the plaintiff is invariably entitled to benefit of the presumption. Mere denial of consideration is not sufficient to discharge the initial burden. Something probable has to be brought on record to prove non-existence of consideration. On facts, execution of promissory note proved. In this case, promissory note was proved. The court said that since the respondents have failed to discharge the initial burden, either by direct evidence or preponderance of probabilities, the appellant is entitled to the benefit of presumption under section 118A of the Negotiable Instruments Act. So this presumption in law is there. If the debtor fails to set this presumption aside, or either by preponderance of probability or anything, that presumption will help me as a creditor always. Now, while dealing with promissory notes, there was a very interesting case before the Honorable Supreme Court, that is Tati Pamula Nagaraju versus Pattam Padmavati, 2011 4 SCC 726. In this case, what has happened was there were 4 promissory notes given by the debtor to the creditor. One was for 50,000 and 3 other were for 25,000. So the total debt was 1,25,000. Now, after that, the debtor fails to repay this. So what the after that, the mediation takes place between the parties, and they settle the dispute of 1,25,000 for 90,000, and the debtor basically pays 90,000 and creditor hands over 3 promissory note back. Out of 4, 3 he hands over back of 50,000 and 2 of 25,000, but one promissory note of 25,000 he retains with him. And what he tells to the debtor is, I have misplaced this promissory note. So the debtor says, anyway, doesn't matter, I've repaid you. The mediator is the party to these proceedings between us. This happens. Now what the creditor does is, he interpolates or tampers with the promissory note, and instead of 25,000, he adds a 1 ahead of 25,000 and makes it 1,25,000, and he files a summary suit for 1,90,000. Now, the matter comes before the trial court. The defendant says, of course, this promissory note is executed by me, but it was only for 25,000, and that amount of 1,25,000 was settled by me in mediation, and I've already paid it. So there, no consideration is to be now paid to the creditor. The court then, also, of course, also relying upon the handwriting expert's opinion, says that the handwriting expert opines that one is added later on, because the one is also not, there's also a little bit more gap between the numbers, and also it's not in the straight line. So the handwriting expert says that this is interpolated, this is tampered with, this promissory note. Then the mediator also comes in and he says, no, this dispute between the creditor and debtor was resolved, and he has paid him 90,000, and he was supposed to give him back the promissory notes, but he has retained one of them and misused it. So when the matter travels to the trial court dismisses the suit and says that no, defendant is correct, this matter is settled, and dismisses the suit. The creditor takes the matter before the first appellate court. First appellate court reverses the order of trial court only on the limited ground that the debtor himself admits that he has executed this promissory note. So he is entitled to this judgment in his favor, and he reverses the order of the trial court. then matter travels to high court. High court being the second appellate court, it does not interfere because there is no important question of law involved. And then the matter travels to Supreme Court, when Supreme Court says that yes, of course, High Court did not entertain being the second appeal, but now we see and that the order of the trial court is correct. There is clearly a tampering with the promissory note, and the defendant should not get the creditor should not get away with this, and defendant ought not to be saddled with a liability to pay the amount which is in pursuance of a tampered promissory note for which no consideration has ever been passed, and the court restores the order of the trial. Now you can ask questions if you have any.
So, Ashish, in the chat box, there's one question. So, do
Yes.
unsecured creditors have any right as they don't enjoy any title over the property?
They have right, of course they have right, uh, but provided what right will come out of some contract or some no promissory note, but they have a right, of course. I've talked about this either in the summary court. If not, if there's nothing on record, if there's no documentary proof, then of course then it's very difficult. But if there is some document, then of course an unsecured creditor also has a right to get a judgment in his favor and then execute that judgment against whatever asset the debtor may have.
The next question is it compulsory to serve a notice under Section 138 matters?
Of course, the statutory notice is compulsory. You have to serve it. You have to give them an opportunity, and if within 15 days they don't pay you back, then your limitation for filing the criminal complaint starts.
And the follow-up question to that is what if the defendant does not receive the notice? What measure can be taken against that?
Depends. If you have the address that is available with you, then there, of course, you can say that there's a presumption that the defendant, which address he had given to me, that is the last known address. So I've given it on him on that address, and then you'll have to say that this is the last known address to us. So we'll have to proceed on that basis. But because
Okay.
in a lot of cases it happens that people take money, then they shift their houses, we may not have their new address, of course, then of course the criminal complaint again in cheating and all that is there available. But in an NI Act also we can go ahead with available address of the accused.
Okay. The next question is do unpaid wages form a part of creditors?
Of course, wages also form a part of creditors under IBC, and they can file their claims before, or if they meet the threshold, they can even file a IBC proceedings.
Okay. Okay. There's one more question. What, according to you, is the best legal remedy to get the debts cleared?
Well, it will obviously depend upon your facts of your case, what documents you have in your favor. If you have a promissory note, then of course summary suits are the best option for you. If you don't have that, if you have a check, then of course 138 proceedings you can also file for cheating, and that will be your best. So I cannot give a straight jacket answer to this question. Of course, this will always be subject to what documents you have in your custody.
What are the proactive steps that debtors can take in order to ensure recovery of debts?
What steps the creditors can take is usually maintain records. Please preserve your records. If you are a creditor, please don't misplace it, the originals, and please maintain correspondence with the debtor. I think so because when you go to a court of law, these are the documents which come in handy and which helps your case. So for a creditor, that is the steps you must take.
The next question is what's the minimum and maximum amount for promissory notes?
There is no such minimum or maximum. Whatever is given can be promised under a promissory note. There's no financial pecuniary limit as such. But of course, there's also the Money Lending Act which can come into, because of course friendly loans will have to be on some reasonable amount of money. If you are indulging into huge financial amounts, then the defense usually taken under 138 Act complaints is that this person is indulging into money lending business and is not having a money lending license and all that.
Okay. So thank you so much, Ashish, for such an illuminating webinar. It
Thank you
was
so
a
much
great
for the
pleasure to
opportunity.
have you again.
Thank you.